Hello, everybody. Guess what? I dug them out. I couldn't go one more stream without having a bag of treats for her. And that's the only thing that I've accomplished today. Yeah, it's hitting me. It's absolutely hitting me, like, hard, like a ton of bricks hitting me. And I haven't been able to do jack today. Not a lick. I still have no curtain. I still have no couch or bed. Tiny Kitten's in that box. So that's the box is there because Tiny Kitten takeover. Yeah, about all that I had the ability to do today was wake up. Oh, I'm so glad to be here with you guys, though. Hello, Nina Laura. Hello, sweet C-Rex. So happy to see you. I miss you at night. I can't wait for the winter when I get to see you all the time again. Hello, Linda Applegate. Oh my gosh. I really hope everything's okay, sweetie. I'll definitely be saying prayers for you guys. Hello, Catherine Gaston. Hello, Joey Bag of Donuts. Yes, I've got to get the day shift in. Got to include the day crew. Me too. I needed this. I really needed this because I can barely move right now. And this will get me going for sure while I wait for the pain meds to kick in. Hello, Eileenie Carlin. Well, thank you. Blue really is my color. Oh my gosh. Yes, I think you need a couple of days off. What is this? I go live and everybody's injured or sick? This is no good. No good at all. I think I jinxed y'all. Hey, Jerry Matthew Boyd, sweetie. Hello, Ian Wilson. Hello, Mortimer Duke. Well, I can't let you have all the fun at night. I gotta let other people get in on this. Hello, Kayla. Great to see you, sweetie. Oh my gosh. Thank you so much. Thank you. Ava will definitely appreciate that. She's a little salty. Yep, she's just a little salty about that box of 52 pods of coffee that ended up being for me. Oh my gosh, I'm still so happy and grateful for that. Oh, thank you. Thank you so much. Oh, I actually just hollered at my daughter and asked her to bring me cetirizine because can you tell I'm all I think that's what Lortab is. Allergy meds, right? Right? I really hope so. I hope I didn't click on something that's going to get me in trouble with you. You're so good at that. Oh, thank you. That makes me feel better. No. What? Oh. Oh, my whoopsie. See, I had no idea. Ugh. Oh, yeah. Yep. You can tell. I'm right from the hood, y'all. I know all the slang lingo. Oh, yeah. If it ain't out my bottle, I got no clue what it is. Unless I heard it in an arraignment. Speaking of which, that's where we're going today. We're going to see some arraignments. And yeah, we're going to see someone who they got lippy with the wrong one. Ha ha, ha 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 ha, ha ha. Funny. No, I don't know. Maybe you don't know my situation, Jerry. I love you to pieces, but yeah, I have a degenerative bone disease that I was born with, and then I got hit by an SUV. So yeah, I have a permanent spinal injury. So yeah, I do kind of, yeah. It's not optional. It's not negotiable. Sorry, I had to mute that. I didn't want to cough in your ear because there's a little bit of an echo with the room being completely empty. Completely empty. Yeah. Just my desk and me. and tiny kitten in a box. All right, guys. Let's have some fun with this one. I think you're really going to enjoy it. I really do. He struts out so confidently right there. He's a legend in his own mind. And you just wait till the judge gets a hold of
The
it.
record in the matter of the state of Michigan versus Dean Davis, 25-02389FY. Counsel Terrence.
Good afternoon, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Assistant Public Defender Joseph Hardy on behalf of Mr. Davis.
This is Dean Davis Jr., is that correct?
Yes.
Okay, Mr. Davis, I do have a felony complaint here that you need to be arraigned on. The allegations are that on or about August 5th, 2025, at the area of 517 North Sycamore Street, which is in the city of Lansing, Ingham County, state of Michigan, that you did allegedly in count one, commit the act of unlawful imprisonment. The allegations are that you did knowingly restrain an Austin Takami Iwahara by means of a weapon or dangerous instrument, and or knowingly restrain Austin Iwahara to facilitate the commission of assault with intent to do great bodily harm, interfering with a crime report, committing a crime, threatening to kill or injure, or interfering with electronic communications, a felony, and or secretly confined and knowingly restrained Austin Iwahara contrary to MCL 750.349B. There's a Sex Offender Registration Act notice indicating that this is a tier 1 offense under the Sex Offender Registration Act if the victim is a minor. It's a tier 2 offense if the defendant has a prior conviction for a tier 1 offense. It's a tier 3 offense if the defendant has a prior conviction for a tier 2 offense. Account 1 is a felony. The maximum penalty is 15 years in prison and or $20,000 in fines. Count 2, assault with intent to do great bodily harm less than murder or by strangulation, alleges that on or about August 5th at 517 North Sycamore, that you did make an assault upon an Austin Iwahara with the intent to do great bodily harm less than murder and this is contrary to MCL 750.84. That's a felony. The maximum penalty is 10 years in prison or $5,000 in fines. Your DNA is to be taken upon arrest. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Count 3, interfering with a crime report, committing a crime threatening to kill, injure, or cause property damage, alleges that on or about August 5th, again at 517 North Sycamore, that you did, through the unlawful use of physical force, prevent or attempt to prevent another person from reporting a crime committed or attempted by another person. And the violation involved committing or attempting to commit unlawful imprisonment or interfering with electronic communications or threatening to kill or injure a person, contrary to MCL 750.4831 and MCL 750.483A2B. That's a felony, maximum penalty, 10 years in prison and or $20,000 in fines. A consecutive sentence may be imposed for any other crime, including any violation of law arising out of the same transaction. Count 4, interfering with electronic communications, alleges that on or about August 5th at 517 North Sycamore Street in Lansing, Michigan, that you did willfully and maliciously prevent, obstruct, or delay by any means the sending, conveyance, or delivery of an authorized communication by or through a telephone line, and that this was contrary to MCL 750.5405A. That's a felony. Maximum penalty 2 years and or $1,000 in fines. Count 5, child abuse, 4th degree, alleges that on or about August 5th at 517. Are you falling asleep, sir?
Not falling asleep, just confused. I don't understand how half these charges or any of these charges. I'm gonna need a lawyer for sure, because it's how did I prevent anyone from doing anything when she willfully called the cops on me? So I just don't understand any of that. She willfully left the apartment. She willfully did anything. How did I prevent anything if she just did those things? She did those things, you know what I mean? Let alone child abuse. We have a child together. How did I abuse the child?
Exactly. I'm sorry, Mr. Hardy, are you representing him today?
Yes, Your Honor. I was able to get an intake done earlier today.
Oh, I'm not used to attorneys allowing their clients just to freely talk, so I'm not gonna
You
stop
asked
him.
me
If
a
he wants-
question. I'm not falling
if
asleep.
I-
That's what's going
I
on.
asked you, were you falling asleep? I didn't ask you to say anything about the facts of the case.
I'm not falling asleep. I'm just confused on how I'm being charged with things that I didn't do.
Okay. Back to
Sir.
count 5, child abuse, 4th degree, that you did knowingly or intentionally commit the following act or acts under the circumstances which posed an unreasonable risk of harm or physical injury to a child by attacking the mother holding that child. Now, this is contrary to MCL 750.136B78. That's a misdemeanor, maximum penalty 1 year or probation for up to 5 years. Count 6 is domestic violence, alleging that you did make an assault or assault and battery upon an Austin Ihawara, an individual with whom you have a child in common, or a resident or former resident of your household, or an individual with whom you had a dating relationship, and that this was in violation of MCL 750.812. That's a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There is an habitual offender, 4th offense notice, says take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about September 20th, 2021, he was convicted of the offense of possession of cocaine in violation of 893.13.6A in the 1st District Court of Suwannee County in the state of Florida. And that on or about September 20th, 2021, he was convicted of the offense of possession of LSD in violation of 893.13 in the 1st District Court for Suwannee County in the state of Florida. And that on or about September 6, 2016, he was convicted of the offense of police officer resist in violation of 843.02 in the 4th District Court for Palm Beach County in the state of Florida. And therefore, the defendant is subject to the penalties provided by MCL 769.12. The maximum penalty you're facing is life in prison if the primary offense has a penalty of 5 years or more. The primary offense in this case does have a maximum penalty of 5 years or more, so you are facing up to life in prison. Do you understand that?
Yes, that's ridiculous. If I get life, that's unbelievable.
I didn't ask for how you felt about it. I asked if you understand the maximum penalty. Okay?
Yeah, I understand it.
I also have file number 25-01864. Let's see here. It looks like that's a domestic violence file that you have pending before Judge Buchanan with the same victim, which means, and I see here that there was a no contact order in place, that you have a final pretrial on August 11th and a jury trial on September 8th. So there's a bond violation pending on that file because you were not to be in contact directly or indirectly with an Austin IOR during the pendency of the domestic violence case. You also were not to commit any crimes or pick up any new charges. So that matter will be set for a hearing before Judge Buchanan on the bond violation, and the court will enter a not guilty plea on your behalf. You have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty, or you can stand mute. I'm gonna repeat, anything that you say on this record can be used against you. And so you have the right in this file, the new felony file, to proceed to a preliminary examination. You have the right to have that preliminary examination within 21 days of today's date, unless the court finds good cause to go beyond that 21 days, or you waive the 21 days. You're currently scheduled for probable cause conference before Judge Stacia Buchanan on August 15th at 9 o'clock in the morning. You have a preliminary examination before Judge Buchanan in person at the court August 22nd, also at 10 a.m. Did you get a notice to appear?
No.
You did not get a notice to appear?
Oh, they just gave it, I guess I haven't had a chance to look at it. They gave it to me 2 seconds before I was called up here.
Okay, and where did you put it, in your pocket?
It's in my hands.
Can you see, make sure you have the correct dates on there?
Friday the 15th, Friday the 22nd.
Very good. Okay, you have the right at the time of your preliminary examination to require the prosecutor establish sufficient probable cause that a felony was committed and probable cause sufficient to charge you with the felony. You have the right to take this matter to trial and the right to maintain your innocence until proven guilty. You have the right to require the prosecutor prove each element of each of the charges being brought against you beyond a reasonable doubt. You have the right to maintain your silence at trial, and that can't be used to prove or imply that you're guilty. You have the right to question or cross-examine in court any of the witnesses called to testify against you, the right to call your own witnesses or present evidence that you believe show a defense to the charge being brought against you. Do you have any questions about those rights?
Yeah, I do not want to waive my right to a speedy trial. I do not want to waive my right to a speedy trial.
We didn't say that you waived your right to speedy trial. We know that you will not waive your right to that, sir.
I do not want to waive my right to speedy trial under any
But that was not
circumstances.
my question. That was not my question. My question is, did you have any questions about any of the rights that I just went over?
No, ma'am.
Okay, what is your address?
517 North Sycamore Street, apartment 2. Lansing, Michigan, 48933.
Is that the address of the protected party?
Yeah, I have another address as well that I can stay at besides there.
Well, obviously, because you already have a domestic violence, so you can't stay with her, and you know that.
I know
Where you
she stays
stay?
at my place. That's my apartment. She stays there. That's fine. Okay. I go to my dad's place. It's 60.
What's your phone number?
30.
Are you on probation or on parole?
Oh. I would just like to say being held against her will, though. I went to the hospital.
Sir. Please stop.
That was the
talking.
day before. And then the day that I got arrested the next day, she just left. Like, at no point did I have her phone, stop her from doing anything. Like, to say that I held her against her will is just ridiculous. Or took her telecommunication device. It's just
Sir, would you stop
ridiculous.
this? Please stop talking.
Okay. I'm just saying there's plenty of evidence that would prove I didn't do that. She left the house multiple times before she came to the decision that she was going to call the police because I didn't want to reconcile with her.
He's not getting this right to remain silent thing. I don't think he understands that part at all.
Counsel, you can address bond.
Thank you, Your Honor. So, Mr. Davis, we do acknowledge the seriousness of the charges. What I would say is that he is someone that has lived in Michigan his entire life. He does have another separate place to stay to keep him away from the alleged victim with the address that he just gave. I would say that according to what he stated to me, is that he does not have a history of failing to appear either. So I don't think there's any danger of him attempting to flee this court's jurisdiction. I do think that these are that with these allegations that any concern for the public could be alleviated through the use of a GPS tether. So I'd be requesting a low 10% bond, Your Honor.
The prosecutor here to be heard on bond.
Yes, Your Honor. First, it appears that he's been misleading his attorney. He's absolutely been charged with failing to appear in prior domestic violence felony
Did not
cases.
tell my attorney. I told my attorney that I
Secondly,
had not appeared before.
He
I'm
has
not the one who's misleading my attorney.
Sir,
I did not mislead my attorney. My
sir.
attorney forgot what I had
Mr.
said.
Davis.
My attorney forgot what I had said.
Mr. Davis, you have
What?
one more outburst and you are remanded and we won't address your bond. Close
Okay,
your
but
mouth.
there's
Close your mouth.
inconsistencies all through here.
Remand, bond denied.
Thank you, Your Honor.
Thank you, Your Honor.
Do I need to go back?
Have a good rest of your day.
Same to you.
Okay, hold up. Apparently, 21 seconds into this,
25-019.
we get his story.
Thank you.
Yes, Judge.
Thank you. On the record, in the matter of the state of Michigan versus David Stoudemire, 25-02049, 25-0198081 and 82. Appearance, please.
Assistant Public Defender Joseph Hardy on behalf of Mr. Stoudemire.
What's your name, sir?
David Stoudemire.
Okay, Mr. Stoudemire, today's the date set for an arraignment. I do have a felony complaint here that I'm going to arraign you on. The allegations are that on or about May 15, 2025, at the area at or near 900 Long Boulevard, that you allegedly committed the act in count 1 of assault with intent to murder, and that you did allegedly make an assault upon a Daniel Thomas Bishop with the intent to murder or the intent to commit the crime of murder, and that this was contrary to Michigan Compiled Law 750.83. It's a felony. The maximum penalty is life or any number of years. Your DNA is to be taken upon your arrest, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There's a count 2 of assault with a dangerous weapon, also known as felonious assault, alleging that on or about May 15, 2025 at 900 Long Boulevard, City of Lansing, Ingham County, State of Michigan, that you did allegedly make an assault upon a Daniel Thomas Bishop with a dangerous weapon, that being a metal weight, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. Count 2 is a felony. The maximum penalty is 4 years in prison and or $2,000 in fines. Your DNA again is to be taken upon arrest, and a consecutive sentence may be imposed if the assault was committed in a place of confinement. There's an habitual offender third offense notice. It says take notice if the defendant was twice previously convicted of a felony or an attempt to commit a felony, and that on or about July 19, 2017, he was convicted of the offense of home invasion, third degree in violation of MCL 750.1108, or in the 30th Circuit Court for Ingham County, State of Michigan, and that on or about July 19, 2017, he was convicted of the offense of aggravated stalking in violation of Michigan Compiled Law 750.411I, in the 30th Circuit Court for Ingham County. Therefore, the defendant is subject to penalties provided by MCL 769.11 that enhances the penalty to twice the maximum sentence on the primary offense or a lesser term. The maximum penalty cannot be less than the maximum term for the first conviction. Do you understand the charge there and the maximum penalty?
Yes.
Okay, file number 25-01980. A misdemeanor. The allegations are that on or about May 19th, 2025, at the area of 5901 Richwood Street in the city of Lansing, Ingham County, State of Michigan, that you allegedly committed the act of assault or assault and battery upon a Joshua Bradley McCoy, contrary to MCL 750.811. That's a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines. A consecutive sentence may be imposed if the assault was committed in a place of confinement. File number 25-01982. The allegations are that on or about June 6, 2025, at the area of 5901 Richwood Street, Lansing, Michigan, that you did willfully and maliciously destroy or injure a building or its appurtenances located at 5901 Richwood that belonged to Joshua Bradley McCoy, and the amount of the destruction or injury was less than $200, contrary to MCL 750.3805. That's a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines, and or 3 times the amount of the destruction or injury, whichever is greater. File number ending in 981. The allegations are that on or about June 5th, 2025, at the area of 5901 Richwood Street, Lansing, Michigan, that you allegedly committed the act in count 1 of malicious destruction of a building less than 200, and that you did willfully and maliciously injure or destroy a building or its appurtenances located at 5901 Richwood that belonged to a Joshua Bradley McCoy. The amount of the destruction was less than $200, and this is contrary to MCL 750.3805. Again, that's a misdemeanor, 93 days in jail and or $500 in fines. You understand each charge that was read, sir, and the maximum penalty that you face in each charge.
I understand the charges.
You have the right to be represented by an attorney, and you have Mr. Hardy here from the Office of the Public Defender. He is here today for the purpose of your arraignment only, to represent you for that purpose. You have the right to be represented by an attorney at all of your court appearances and if you're questioned by law enforcement. If you cannot afford to hire an attorney, you have the right to make a request to have the Office of the Public Defenders appointed to represent you. Do you understand that?
I understand that.
You have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, each of these files will go to a jury trial. The first file that we began with today is a felony file. Because you're being charged with felonies in both counts 1 and count 2, you have the right in that file to proceed to a preliminary examination. You have the right to have that preliminary examination within 21 days of today's date, unless you waive the timeline for that or the court finds good cause to go beyond the 21 days. You understand that?
I understand that.
At the time of your preliminary examination, you have the right to have the prosecutor establish that they have sufficient probable cause that a felony was committed and sufficient probable cause to charge you as the individual who committed the felony. We're currently scheduled for probable cause conference on August 15th at 9 o'clock in the morning before me, Judge Kristen Simmons. And that you can appear via Zoom or in person for the probable cause conference. You have a preliminary examination before me on Friday, August 22nd at 9 o'clock in the morning. You must appear in person for that. Did you get a notice to appear for that court date?
I think so. I got some court notices here, so I think so.
Don't think so. I just asked you, you got it in front of you, use your eyes to look. Do you have one
Okay.
for a felony to appear before Judge Simmons on the dates that I just gave you? Because I don't want you to leave here and then when you don't show up, you tell me, well, I didn't have that paper.
I got the paper. It says 08/15/25 9 a.m.
Okay, and then what, is there another date on there?
Yep, 8/22/25 9 a.m.
Thank
and
you. The other-
8/18.
Very good. And that's for your other 3 files, which are misdemeanors. They do not have a preliminary examination date. So your next dates on those 3 files are pre-trials. I'm assuming they're all of those are set before me as well, Judge Simmons, and those will be on August 18th at 10 o'clock in the morning. Okay?
Okay.
In each of these files, you have the right to the presumption that you're innocent. And you can take these matters all the way to a trial, that being a jury trial, and maintain your innocence until proven guilty. You have the right to require the prosecutor prove each element of each of the charges being brought against you beyond a reasonable doubt. You have the right to maintain silence at trial and not have silence be used against you. You have the right to see, hear, or question any witness that the prosecutor calls to testify against you. The right to subpoena witnesses to testify on your behalf and present evidence that you believe show a defense to the charges being brought against you, and a right to waive silence and testify at your trial. Do you have any questions about those rights?
No, I don't have any questions.
Are you currently employed?
No.
How do you support yourself?
Family members.
What's your home address?
I don't have a home address right now.
Where do you sleep?
I've been sleeping at different hotels.
At different hotels?
Yep.
And how are you paying for these hotels? Family members are paying for?
Yep, some of my family members.
Where do you receive your mail?
On Churchill, 3801.
What's your phone number?
51.
Are you on probation at this time?
No,
Are you on parole?
no.
Is he requesting the public defender to represent him, counsel?
Yeah, yes, Your Honor. He's filled out an application. I'll be able to get all the necessary information from him.
he's lost. I don't even think that there's a soul in there. Dude, you tried to kill the guy. And you're just like, nah, whatever. Oh, there's the hair, C-Rock.
Just bond.
Thank you, Your Honor. So, we do acknowledge the seriousness of the allegations against him. I would say that they are still just those allegations for which he does still enjoy his presumption of innocence. What he stated to me is that he is someone that has never missed court. He's someone that's lived in Michigan for most of his life. So I would say he's definitely not a flight risk. And I would say that just for the previous felonies, while those are serious convictions, I would say that those are not necessarily violent offenses. So at this point, I'll be requesting that Mr. Stoudemire be awarded either a PR or a low 10% bond with the GPS tether.
Kidding me.
I have 4 files that are opening, one being a felony. Assault with intent to murder is the first count. He's being charged as an habitual third offender. And the argument is that because he lived here all of his life, that makes him not a flight risk, so that he should get a personal recognizance bond. He's not even eligible for a personal recognizance bond. These are complete and utter risks to the public safety. I have a bond recommendation here. It says the defendant was either on parole, probation, or has other pending criminal matters. It says defendant has multiple unrelated assaultive crimes occurring within days of each other, which some of those I just read on this record. The defendant and the victims are strangers to each other. And these are violent, unprovoked, or unprompted attacks. The defendant threatened to come back after this attack. And in quotations, it says, with a gun for this cracker. It says, the people are requesting no bond under MCR 6.106B1 and a no contact order for the protection of the alleged victims. I think that the request is appropriate from the prosecution's office. Even as I reviewed his criminal history, I've seen for the last 10 years, nothing but assaultive actions, home invasions, and destruction of people's property. And so if true, when I have 4 pending different files from different dates of events, these are not the same dates of events. These are dates within 2 weeks of each other. Some of them only within days of each other. If true, he's a menace to society and he does not need to be on the street. Bond in file number 25-02049 is denied. Bond in file number 25-01980 is 1,000 cash surety. Bond in 25-01981, 1,000 cash surety. Bond in 25-01982, 1,000 cash surety. There's a no contact order in place for the protection of the alleged victim in file number ending in 49, a Daniel Thomas Bishop, which I believe he is, well, let's see. And file number 8 ending in 80, no contact with a Joshua Bradley McCoy. And file number ending in 81, McCoy is also the protected party on that one, and I believe he's also the protected party on file number in 82. Also, while out on bond, you're aware, well, if you were able to post bond, and that's only after we have addressed the felony file, because as of right now, you're not eligible to post bond. But when you are eligible to post bond on the other files, you're not to possess a firearm, ammunition, or any weapon of any kind. Not to travel outside the state without prior approval of the court. You're not to use drugs or alcohol unless you have a valid prescription, and you'll wear a GPS tether. You have any questions at this time, sir?
Me?
Yeah, that is correct.
No, I don't have any questions.
Okay. Any additional matters for the record, counsel?
No, Your Honor.
You're all set, Mr. Stoudemire.
Dag nabbit. Do you want the list alphabetically or chronologically in terms of what is wrong with this man? Because she just listed a whole host of what is wrong with this man. Yeah, you're right. Well, the mystery is solved, folks. We finally found out who stole the cookie from the cookie jar. It was this guy right here. I don't think his mama raised him at all. He was probably raised by his grandmama with no daddy in sight. That's all I got for this one. But we should be 22 minutes into, or 21 minutes into it, so we should be able to hear the story of our double casted boy coming up next.
Mr. Piper, which matter are you here for?
Your Honor, I am here on the Dean Davis file. I believe it was a late addition to the arraignment lineup today.
Oh, was the one that came after the
Yep.
cutoff?
That would be the one.
I don't know if I put bottom on that. Misdemeanor file.
It must be in the talking part. Oh, yay! Yep, this is Billy O.T. He started the Paw Firm. It is because of him that we are all here, sort of. Yeah, he was dubbed Lawyer Kitty. And that is exactly what started everything. Our favorite Lawyer Kitty.
On the record in the matter of the state of Michigan versus Dean Davis,
Okay, hold on.
25-023.
So that's the case that we started out with, but Catherine Gaston said at 21 minutes we hear the story of what happened. The stream must be over for it to be. Hey, don't you bite me. Get out of here. Out of here.
Off the record.
Oh, we gotta go back and see the rest of these. Oh, he's an angel. He truly is. Oh, wait, I pronounced asshole wrong. Okay, Catherine, honey, Can I get an updated timestamp since you're the one that knows where it's at? Thank you, Rocky Lennon, sweetie. I practically have them. That's basically what Billy is. I named him after my favorite sea shanty, the Wellerman. There once was a ship that put to sea. Yeah, y'all know that one. That's what Billy O.T. is named after.
My apologies for that, Your Honor. My laptop was at 10%, then it was dead. But regarding the bond, Mr. Puddles has stated to me that he's someone that comes to court, someone that is fully employed, someone that has lived in Lansing.
Hold up, 21 minutes into my stream. So it was during his case. He explains it. Okay, hold on. Okay, so Glove Man basically says he just got out of the hospital because other people did it to him. Mr. Earl Grey was named, that's my daughter's cat. And I wanted to name Earl. I wanted to name Earl Billy O.T. because we were trying to think of food names because my daughter likes to name all of her pets after food. And so I suggested tofu, and she really liked tofu. And then she decided she wanted to name him Earl. And I personally just didn't like the name. I really didn't. I'm like, Earl. You know, the abusive POS husband in every country song that the wives, bury under an apple tree. But that's what you want to name your cat, Earl. And she's like, well, not really. It's Earl Grey the cat. So she got to keep it. Obviously, since it's her cat, she got to keep the name. And I eventually warmed up to it. And Billy O.T. showed up on my lawn less than a week later, so emaciated that I could count his ribs from the top of my handicap ramp. And I had to save him. And he's now my baby. He's spoiled rotten, and he doesn't even know. He doesn't even remember how bad his life was prior to the PAWFURM. That's okay, though. Can't blame him. He's, he was so emaciated that I'm assuming it did some brain damage. All right. We are going to go to the end of Glove Man, since we already watched it, and we're gonna rewind. So the story of how he got his gloves is in his testimony. We'll be able to catch it on Replay Crew. All right. Oh, he's such a piece. That being a piece is not like being a snack.
Close your mouth.
Inconsistency all through here.
Remand. Bond denied.
Thank you, Your Honor.
Thank you, Your Honor.
Have a good rest of your day.
Thank you.
I love that y'all are singing the Wellerman. Well, it was Patrick Stewart's favorite tea. Four minutes. Oh my gosh, you guys are something else. Okay, hold on. We're at 131. 2, 3, 4. You know what? It's not that long. Whoa, I guess it is. I guess he talked a long time. Okay.
Being brought against you. Do you have any questions about those rights?
Thank you.
Yeah, I do not want to waive my right to a speedy trial. I do not want to waive my right to a speedy trial.
We didn't say that you waived your right to speedy trial. We know that you will not waive your right to that, sir.
I do not want to waive my right to a speedy trial under any
But that was not
circumstances.
my question. That was not my question. My question is, did you have any questions about any of the rights that I just went over?
No, ma'am.
Okay. What is your address?
517 North Sycamore Street, apartment 2. Lansing, Michigan, 48933.
You guys send me on more
Is
scab.
that the address of the protected party?
Yeah, I have another address as well that I can stay at besides there.
Well, obviously, because you already have a domestic violence, so you can't stay with her, and you know that.
I know
Where you
she stays
stay?
at my place. That's my apartment. She stays there. That's fine. Okay. I go to my dad's place. It's 6740 North Burkhart Road, Howell, Michigan.
What's your phone number?
305-434-5402.
Dang it, I didn't get to mute that quick enough. Sorry, guy. Don't call him. He's not worth it.
Are you on probation or on parole?
No. I would just like to say being held against her will, though. I went to the hospital.
Sir. Please don't.
That was the day before. And then the day that I got arrested the next day, she just left. Like, at no point did I have her phone, stop her from doing anything. Like, to say that I held her against her will is just ridiculous. Or took her telecommunication device. It's just ridiculous.
Please stop talking.
Okay. I'm just saying there's plenty of evidence that would prove I didn't do that. She left the house multiple times before she came to the decision that she was going to call the police because I didn't want to reconcile with her.
Counsel, you can address bond.
Thank you, Your Honor. So, Mr. Davis, we do acknowledge the seriousness of the charges. What I would say is that he is someone that has lived in Michigan his entire life. He does have another separate place to stay to keep him away from the alleged victim with the address that he just gave. I would say that according to what he stated to me, is that he does not have a history of failing to appear either. So I don't think there's any danger of him attempting to flee this court's jurisdiction. I do think that these are with these allegations that any concern for the public could be alleviated through the use of a GPS tether. So I'd be requesting a low 10% bond, Your Honor.
The prosecutor here to be heard on bond.
Yes, Your Honor. First, it appears that he's been misleading his attorney. He's absolutely been charged with failing to appear in prior domestic violence felony cases.
Tell my attorney. I told my attorney that I
Secondly,
not appeared before.
He
I'm
has
not the one misleading my attorney.
Sir,
I did not mislead my attorney. My attorney forgot what I had said.
Mr. Davis.
My attorney forgot what I had said.
Mr. Davis, you have one more outburst and you are remanded, and we won't address your bond. Close your mouth.
There's inconsistencies all through here.
Remand. Bond denied.
Thank you, Your Honor.
Thank you, Your Honor.
So worth seeing again.
Have a good rest of your
anyway.
day.
Same to you.
Okay, I thought there'd be more to it. That's okay. It was worth seeing that again. What a piece. Oh man. He's one of those guys that got blessed with, slightly above average looks, and he's just a total jerk. And for some reason, that makes women like swoon and flock to him. But it's gross. He's gross. He's another one. His mama didn't raise him right. Actually, I'm gonna start saying your daddy didn't raise you right. I guess the only what we just saw, that was the only mention of it, was just that he went to the hospital the day before and then came home and didn't want to get back with her, so she made all these wild allegations. Yeah.
On the bond violation, remand for a hearing.
Most of them. The narcissist I just kicked out.
Okay, on the record, in the matter of the people of the state of Michigan versus Jeffrey Tabor, 24-01373, appearance please.
Thank you, Your Honor. Good afternoon, Justin English on behalf of Jeffrey Tabor, P71565.
You say you're Jeffrey Tabor, sir?
Yes, ma'am.
Okay, Mr. Tabor, I do have a misdemeanor complaint to warrant here. Let's see, the allegations allege that on or about March 31st, 2024, at the area of 1215 East Michigan Ave, City of Lansing, Ingham County, State of Michigan, that you did allegedly commit the act of aggravated assault. It said that you did allegedly make an assault without being armed with a weapon upon a Jennifer Boland, and did inflict a serious or aggravated injury upon said person, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. That's a misdemeanor. The maximum penalty is 1 year in jail and or $1,000 in fines, and a consecutive sentence may be imposed under the law if the assault was if imposed in a place of confinement. You understand the charge and the maximum penalty?
Yes, Your Honor.
Okay, you have retained counsel to represent you for this matter, that's correct?
That's correct, Your Honor.
Okay. So he's declining court-appointed counsel. The court will note that at this time. You have the right in this matter to remain silent. Anything that you say, anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, this matter will go all the way to a jury trial, okay?
Yes, Your Honor.
Okay, you have the right in this matter to have a jury trial and maintain your innocence until proven guilty, and require the prosecutor to prove your guilt by proving each element of the charge of aggravated assault beyond a reasonable doubt. You have the right to see, hear, or question any witness the prosecutor calls to testify against you, the right to subpoena witnesses to testify on your behalf, and the right to remain silent and not have silence be used against you, or you can waive silence and testify at trial if you like. You understand that?
Yes, Your Honor.
Okay, let's see. You're currently scheduled for a pretrial conference before Judge Tony Flores on August 26th at 9:30. Right, and we'll make sure you and your attorney get a notice to appear. You should have received one in the jail, is that correct, Mr.
Thank
Tabor?
you, Your Honor. Yes, I did.
Okay. Where are you employed? Are you employed?
Oh, yes, yes, ma'am.
Where are you employed?
The name of the company is 59 Incorporated.
Can you repeat that for me?
That's 59, the word 5, and then the number 9, Incorporated. We're a cloud-based contact center solution for financial industry.
He looks every bit that role.
What's your home address?
3476. No, I'm sorry, MCONNE. Yeah, highway.
What's your phone number?
Sorry, let's do it again. 20.
6859.
That's where I lived for about 28 years before moving back here to Michigan.
Oh, gotcha. Okay. Let's see. Council, you can address bond.
Thank you, Your Honor. Mr. Tabor is originally from Michigan. He did live in Birmingham for several years before moving back here. He has no criminal history other than a prior, I believe, OWI, which is quite old. He has no assault history. The allegations in this case involve a hospital worker while he was receiving hospital treatment. He's employed. He does travel for work. I know usually conditional bond is not leaving the state. He has 2 travel trips planned right now. One is August 25th to the 27th for work, and the other is September 12th to the 22nd of September.
Where?
I'm sorry, Mr. Tabor, where were you going for those 2 trips?
Yeah, the first trip is going to Richmond, Virginia, and that's an employee training team building exercise. And then the travel, and I'm sorry if I misspoke, the travel in September is to visit our kids in Alabama.
Oh, I'm sorry. I thought that was another work trip.
Richmond, Virginia, August when?
25th through the 27th.
And then there is,
Here, it's I guess I must have understood. The September trip was a family trip to in September to Alabama for from September 12th to the 22nd.
September 12th to when?
The 22nd.
They're in Birmingham as well.
Yes.
Tabor.
Yes, ma'am.
And Mr. Tabor did turn himself in on this. He learned of a warrant. His wife got pulled over for some traffic infraction, and the police officer informed her that there was a warrant for her husband's arrest. Once he learned that, he did turn himself in to get this taken care of, hired our office. We got it worked out.
Our bond is set in the amount of 500 personal recognizance. There's a no contact order in place for the protection of Jennifer Boland. You're not to have contact directly or indirectly with Jennifer Boland. I'm assuming Jennifer Boland works at Sparrow, so I'm not gonna say you can't be where she works, but you can only be at Sparrow if you are receiving medical treatment, okay?
Understand?
Thank you, Your Honor.
Let's see. And you're not to engage in any assaultive or threatening behavior. You're not to travel outside the state without prior approval. Your request that was stated here on the record are both approved. You are not to use drugs or alcohol without a prescription. You're not to possess a firearm, ammunition, or a weapon of any kind. You have any questions about your bond conditions?
No questions, Your Honor.
Any additional matters for the record, counsel?
No, Your Honor. Thank you.
Thank you. Let's see, on the record in the matter of the state of Michigan versus Rayshawn Worthy, 25-02387. Appearance, please.
Assistant Public Defender Joseph Hardy on behalf of Mr. Worthy, who is walking in and appearing via Zoom. Thank you.
Okay, you're Rayshawn Worthy.
Yes, Your Honor.
Okay, Mr. Worthy, I have a felony complaint here. The allegations are that on or about August 5th, 2025, at 330 East Elm Street, Lansing, that you committed the act in count 1 of assault with intent to do great bodily harm, less than murder or by strangulation, and that you did make an assault upon a Desiree Terry Lynn Allen Marion by strangulation or suffocation, and that this was contrary to MTL 750.84. Count one is a felony with a maximum penalty of 10 years in prison or $5,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Count two, domestic violence, alleges that on or about the same date and time at the same location that you did make an assault or assault and battery upon Desiree Terry Lynn Allen Marion, an individual to whom you had a dating relationship, and that this was done contrary to MCL 750.812. That's a misdemeanor. The maximum penalty is 93 days in jail and or $500 in fines. Again, a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. You are, however, charged as an habitual offender, fourth offense notice. It says, take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about September 11th, 2018, he was convicted of the offense of tampering with an electronic communication device in violation of MTL 771.3F in the Fourth Circuit for Jackson County in the state of Michigan. And that on or about January 15, 2019, he was convicted of the offense of assaulting, resisting, or obstructing the police in violation of MCL 750.81D1 in the Fourth Circuit Court for Jackson County, state of Michigan. And that on or about January 15, 2019, he was also convicted again of assaulting, resisting, or obstructing a police officer in the Fourth Circuit Court for Jackson County. Therefore, the defendant is subject to the maximum penalty of life in prison if the primary offense has a penalty of 5 years or more. Your primary offense does have a maximum penalty of 5 years or more. You are facing a maximum penalty in life in prison at this time. Do you understand that?
Yes, Your Honor.
You have the right to be represented by an attorney. Mr. Hardy is representing you for your arraignment only, but you do have the right to have an attorney represent you at all of your court dates and if you are going to be questioned by law enforcement. If you can't afford to hire an attorney, you can make a request to have the public defender's office appointed at no expense to you. Do you understand that?
Your Honor.
You have the right to remain silent. Anything you say, anything you put in writing can be used against you. You can plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will go all the way to a trial. You are being charged with a felony, so you have the right in count one to have a preliminary examination within 21 days of today's date. You have the right to have that within 21 days unless you waive that timeline or the court finds it a cause to go beyond the 21 days. You have the right to require the prosecutor at the time of your preliminary examination to establish that they have sufficient probable cause that the felony you're being charged with was committed and a sufficient probable cause to charge you with a felony, okay?
Yes, Your Honor.
You're currently scheduled for probable cause conference before me, Judge Kristen Simmons. Is going to be on August 15th at 9:30. You have a preliminary examination before me in person at the court, August 22nd at 9:30. You should have received a notice to appear. Can you confirm?
Yes, I did, Your Honor. I received it.
Okay, you have the right in this matter again to proceed to trial and to maintain your presumption of innocence. So you're innocent until proven guilty. You have the right to maintain that innocence and have the prosecutor prove each element of each of the charges beyond a reasonable doubt. You have the right to maintain silence at any trial and not have silence be used against you, or you can waive silence and testify at your trial. You have the right to subpoena witnesses to testify for you at trial, and the right to see, hear, and question any witness that's called to testify against you. Do you have any questions about any of those rights?
No, Your Honor.
Are you currently employed?
Yes, Your Honor.
Where?
I work for Roxy Cafe. It's a restaurant in Jackson, Michigan. On Ganson.
What's it called?
Roxy Cafe.
Roxy Cafe. What's your phone number?
517-299-300.
Are you on probation or on parole?
No, Your Honor.
Do you have any other criminal matters pending?
PPO violation, that's it. It's out of 30th Circuit Court. They just PR bond me for it today.
You have a PPO in 30th Circuit?
Yeah, I just was arraigned on it today because of
Okay,
the charges that right now.
Is the protected party is Desiree?
Yes, Your Honor.
Is he requesting the public defender to represent him?
He is, Your Honor, and I was able to speak with him and complete an intake.
Okay, the court wants your plea of not guilty on your behalf. Let's see.
They all did too. They all did too.
You can address bond.
Thank you, Your Honor. So, what we do acknowledge the previous habituals that you kindly listed off. I would just say that the most recent pair being the felony RNOs in 2019. I would say that none of those previous felony convictions involved any type of acts of domestic violence against this partner or against anyone else. So I would say that these somewhat dated, but at least by 6 years, offenses are not indicative of any type of future danger or harm to society. He does admit to at one time failing to appear because he forgot his court date, but he represented to me that this was a case of him simply forgetting his court date, and he addressed it as soon as he did without having to get picked up for it. He's lived in Ingham County for at least 2.5 years, and Michigan his entire life. And as he's previously stated, he does work at Rotzi Cafe, and all these any type of concern that the courts may have regarding harm to society, I think could be alleviated by the use of a GPS tether. So with this, I would just be requesting a PR bond.
Maybe I'm missing something. He has a PPO with the same victim. So that right there is a presumption that at least the circuit court believes that there was enough grounds to grant a protective order for this person that allegedly he was with in violation of this PPO with yesterday and allegedly committed a domestic violence and an assault with intent to do great bodily harm less than murder and is facing life. I looked at his prior criminal history. He has over 15 prior charges of assaultive actions. 15 times he's been charged with something assaultive. He's a threat to the public safety. Bond in this matter is set at $50,000 cash surety with a GPS tether. There's a no contact order. You're not to have contact directly or indirectly with the protected party, that being the Desiree Terry Lynn Allen Marion. You can't call her. You can't text her. You can't call her from the jail. You can't have anybody else call her on your behalf while you're in the jail. You can't be within 2,000 feet of wherever she is for whatever reason. Do you understand that?
Yes, Your Honor.
Do you have any questions, comments, or concerns or confusion about a no contact order?
As far as the PPO, I think that they only
I'm not talking about your PPO.
violated my.
I'm not talking
violated-
about you. I'm not talking about your
know.
PPO. Do you have any questions, comments, or confusions about the no contact order that I
No,
just
Your Honor.
issued?
No, Your Honor.
While out on bond, you're to wear a GPS tether. There'll be victim notification if possible. You're not to possess a firearm, ammunition, or weapon of any kind. You must report to pretrial services within 48 hours of your release. You're not to use alcohol or drugs without a prescription. You're not to travel outside the state without prior approval of the court. You need to be at all your future court dates. You'll see me on the 15th. Do you have any questions?
No, Your Honor.
Any additional matters for the record?
No, Your Honor.
You're all set. On the record in the matter of the state of Michigan versus Rashid Balungo, 25-02329, appearance please.
Assistant Public Defender Joseph Hardy on behalf of Mr. Belongo.
She is tough. She's not to be messed with.
Okay. This is the second file that I've not had a criminal history on, because I didn't have one on the one that was uploaded by him. Oh wait, I might have misspoke. Hold on. I do have it. Okay, Mr. Belongo, is that correct?
Yes.
Okay, Mr. Belongo, I have a felony complaint here that alleges that on or about August 5th, 2025, that you did allegedly commit the act of assault with intent to do great bodily harm, less than murder or by strangulation, and that on or about August 5th, that at the address of 1037 Vincent Court, City of Lansing, Ingham County, State of Michigan, you did make an assault upon a Carmine Guittari and by strangulation or suffocation, and this is contrary to MCL 750.84. That's a felony. The maximum penalty on count one is 10 years in prison or $5,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Count two, domestic violence, alleges that on the same date and time at the same location, you allegedly committed an assault or assault and battery upon a Carmine Guitar, a resident or former resident of your household, or an individual with whom you had a dating relationship, and that this is contrary to MCL 750.812. That's a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand the charges read in count one and count two and the maximum penalty on both?
Yes.
Okay, you have the right to be represented by an attorney. Mr. Hardy's going to represent you today to be arraigned. You have the right to have an attorney at all of your court appearances and if you're questioned by law enforcement. You have the right to remain silent. Anything that you say, anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will go all the way to a jury trial. You have the right to request the public defense office to represent you if you cannot afford to hire your own attorney. Do you understand your right to counsel?
Yes.
Is he requesting the public defender's office?
Yes, Your Honor. I was able to speak with him and I was able to complete an intake. However, I would note that he is requesting a Swahili interpreter for any future proceedings.
Thank you. Let's see, Mr. Belongo, again, you have the right in this matter to have a preliminary examination because count one is a felony. You have the right to have that within 21 days of today's date unless you waive the 21-day timeline or the court finds good cause to go beyond that to reset it beyond 21 days. You're currently scheduled for probable cause conference before Judge Cynthia Ward on August 14th at 9 a.m. You have a preliminary examination before Judge Ward on August 21st at 9:30. You must appear in person. Did you get a notice to appear?
Yes.
And is the date that I just said what you got on your notice to appear?
Yes.
Okay. You have the right at the time of your preliminary examination to require the prosecutor establish that they have probable cause sufficient to charge you with the felony that you're being charged with. You understand that?
Yes, ma'am.
You have the right to proceed to trial and maintain your innocence and to have the prosecutor prove each element of the charges being brought against you beyond a reasonable doubt. You can maintain your silence even at trial, and they can't use that to prove or imply that you're guilty. You can waive your silence at trial if you like and testify, or you can subpoena witnesses that will testify on your behalf. And you have the right to present evidence at your trial to show a defense to the charges being brought against you. Lastly, you have the right to see, hear, and question in court any witness called to testify against you. Do you understand me?
Yes.
Okay. Do you have any questions at this time?
No.
Are you employed?
No.
You said no. How do you support yourself?
Sorry.
Are you employed?
No, I'm not employed.
How do you pay your bills?
I do hair.
You say
That's
you do
home.
hair?
Yes.
What do you do to hair?
I'm a salonist.
You're who?
Hairdresser.
You're a hairdresser?
Yes. I just
Oh,
do
so then
home.
you do hair at home?
Yes.
And what do you do to the hair? What are you doing? Are you styling? Are you cutting? What are you doing?
Style. I do
Okay.
dreadlocks.
Okay, so people pay you for that?
Yes, ma'am.
What's your home address?
1039 Vincent Court.
Is that Carmine's address?
Yes.
Well, you can't stay there while this case is pending. So where are you gonna stay?
Sorry.
You cannot stay there while Carmine is staying there. So where are you going to stay?
Oh. Means I have to go back in Indiana police.
Back to Indiana.
Yes.
Well, you were living in Indiana prior to this?
Yes.
Okay, well, you're not allowed to leave the state while this case is pending.
Okay.
Where
I will leave
are you gonna stay?
my friend's house.
Where is that?
His name Musa.
Where does he live?
Oh, the address, I don't remember his address. It's like 25 minutes to Carmen house.
You don't know where, does he live in Lansing?
Yes.
But you don't know the address?
Yes.
What's your phone number?
317-2233-196.
You have any other court cases pending at this time?
Excuse me?
Are you on probation or parole?
No,
You're not on probation?
yes,
I just asked you, were you on probation or parole? Where are you on
No, I'm-
probation?
I'm supposed to start a probation on 7.
What court?
Oh, Charlotte Court.
56A District Court?
Yes.
You're on probation for 12 months?
Mm-hmm. Yes, ma'am.
Oh, okay. Counsel, you can address bond.
Thank you, Your Honor. So, Mr. Bolingo is someone who has lived in Michigan for
Hold on, I'm trying here, guys. My internet just went down. Ugh, why does stuff like this always happen? Hold on, I'm not good at this on my phone. Come on. There we go. Okay, I got that part figured out. Now, how do I put me? No. I can't do anything on this. Okay. Oh, here's this. Oh, no, wrong one. There I am. Okay. Okay. Hold up. I'm reconnected. I can do this. Hold on, I'm figuring it out, guys. Bear with me. Okay. Stop. It never comes back up. Okay. It'll stop soon. I just turned the volume down. Come on. Oh my god. Get me off of here. Okay, I got it. Stop it. Oh my God. Don't ever become a professional streamer. I was trying. I knew exactly what I had to do, but it wasn't letting me do it. And I tried pushing the volume down, and I thought, you hold the volume down, the volume goes all the way down. Well, I held the volume down, and then when I spoke again, it started looping again, and it was because when I pushed the volume, instead of adjusting the volume, it just said mic is muted. Okay, I'm back. My internet just randomly just went out, completely dead, gone. This is why I don't stream in the daytime. And when it goes down at night, it just stays down. Okay, I am back. Oh, I never lost interest. I was here the whole time, freaking out. Dang it, dang it, dang it, dang it. Okay, we have got, I've got to back up. I have to see. I mean, at least this dude in his pajamas. Oh my gosh, I blame Spectrum. It's their fault. And my phone company just got bought out by T-Mobile. So I'm sure there's going to be all kinds of changes with that. Yeah, fun times. All right, I got to reset everything up. Dag nabbit. It's all right. We'll survive this. We'll get through it together.
Yes.
And is the date that I just said what you got on your notice to appear?
Yes.
Okay. You have your notice to appear?
Yes.
Okay. You have the right at the time of your preliminary examination to require the prosecutor establish that they have probable cause sufficient to charge you with the felony that you're being charged with. You understand that?
Yes, ma'am.
You have the right to proceed to trial and maintain your innocence and to have the prosecutor prove each element of the charges being brought against you beyond a reasonable doubt. You can maintain your silence even at trial, and they can't use that to prove or imply that you're guilty. You can waive your silence at trial if you'd like and testify, or you can subpoena witnesses that will testify on your behalf. And you have the right to present evidence at your trial to show a defense to the charges being brought against you. Lastly, you have the right to see, hear, and question in court any witness called to testify against you. Do you understand me?
Yes.
Okay. Do you have any questions at this time?
No.
Are you employed?
No.
You said no. How do you support yourself?
Sorry.
Are you employed?
No, I'm not employed.
How do you pay your bills?
I do hair.
You say
That's
you
home.
do hair?
Yes.
What do you do to hair?
I'm a salonist.
You're who?
Hair dress.
You're a hairdresser?
Yes. I just do
So
home.
then you do hair at home?
Yes.
And what do you do to the hair? What are you doing? Are you styling? Are you cutting? What are you doing?
Style. I do dreadlocks.
Okay, so people pay you for that?
Yes, ma'am.
What's your home address?
1039 Vincent Court,
Is that Carmine's address?
Yes.
Well, you can't stay there while this case is pending. So where are you gonna stay?
Sorry?
You cannot stay there while Carmine is staying there. So where are you going to stay?
Oh. Means I have to go back in Indiana police.
Back to Indiana.
Yes.
What, you were living in Indiana prior to this?
Yes.
Okay, well, you're not allowed to leave the state while this case is pending.
Okay.
Where
I
are
will leave
where are you gonna stay?
my friend's house.
Where is that?
His name Musa.
Where does he live?
Oh, the address, I don't remember his address. It's like 25 minutes to Carmen house.
You don't know where, does he live in Lansing?
Yes.
But you don't know the address?
Yes.
What's your phone number?
317-2233-196.
You have any other court cases pending at this time?
Excuse me?
Are you on probation or parole?
No.
You're not on probation?
Yes.
I just asked you, were you on probation or parole? Where are you on
No,
probation?
I'm supposed to start a probation on 7.
What court?
Oh, Charlotte Court.
56A District Court?
Yes.
You're on probation for 12 months?
Mm-hmm. Yes, ma'am.
Oh, okay.
I must have missed some good stuff.
Counsel, you can address bond.
Thank you, Your Honor. So, Mr. Bolingo is someone who has lived in Michigan for about 1 year now. I would say that his criminal history is not one that reveals himself to be any type of violent person. He's stated to me, at least according to his memory, that he's not someone that has been issued a bench warrant for missing court. So, with the long time that he's lived here and also the lack of failures to appear, I would say that he's not particularly a flight risk. And, despite the seriousness of the charges, I would say that his history does not reveal him to be a violent person either. So at this time, I'd be requesting a PR bond.
So you consider living in the Michigan for 1 year a long time? Counsel?
Yes.
I do.
Well, we've seen how this went already with guy number 2, who was technically guy number 1, when the judge called out his interpretation of a nonviolent offender who has lived in the area and deserved a PR bond. Let's see how it goes for him this try.
It's not, I would say it's not indicative of him trying to return. I would say this is clearly not a vacation situation. He does have income here from doing here.
That's
And
not
that's-
what he said. He said he's unemployed, and he told me he could just go back to Indiana. That's what he said, actually. The other concern is, yeah, he's not employed. He doesn't have stable housing here because it sounds like he lives with the protected party. And when I asked him where he could stay, he couldn't provide me with a valid address. He said he could just go back to Indiana. But notwithstanding any of those things, no, he's on probation. He's under court supervision right now. And I'm positive that Eaton County didn't tell him he could leave the state, nor is Eaton County gonna not violate him for having a new charge, assaultive crime that pended within 1 week of him being placed on, he was just placed on probation a week ago. So he's not eligible for a PR bond because he's under court supervision. Also, the court does believe that there is a concern that he's not going to return back to court, or that we're not going to get a valid address for him. And so with that being said, the people did request bond to be set at $100,000 cash surety. They said that the issue that they see as a protection for the public under MCL 765.6 and MCR 6.106F, because the crime involves violence towards another person in an intimate partner relationship. It says they were requesting that the defendant have a cash surety bond, that he be ordered not to be in the presence of Carmine Guitar, and that he's not to be in contact directly or indirectly, and not to possess any firearm or dangerous weapons. I think $100,000 is a bit more than necessary to secure the public and the safety in this particular instance, but bond will be set in the amount of 10% with GPS tether. There's a no contact order. You're not to have contact directly or indirectly with Carmine. Do you understand that?
Yes, ma'am.
You can't speak to her, you can't call her, you can't text her, you can't have anybody else call her, nobody else can text her, you can't go by her house, you can't be at the same supermarket where she is, you can't go by her job, you can't call her from the jail. Do you understand that?
Yes, ma'am.
So no communication of any kind. You're not to possess a firearm, ammunition, or weapon of any kind. You, again, cannot leave the state unless you get permission from the court first. You understand that?
Yes.
You need to report to pretrial services within 48 hours of your release. You're not to use alcohol or drugs without a prescription, and you need to make sure you appear for all of your court dates. Do you have any questions? Any additional matters for the record, counsel?
No, Your Honor.
You're all set, sir. This is the matter of the state of Michigan versus Kathy Arnold, 25-02383.
Ooh, it's Ladies' Day.
Parents, please.
Assistant Public Defender Joseph Hardy on behalf of Ms. Arnold.
You're Kathy Arnold?
Yes, I am.
Okay, Ms. Arnold, I have a felony complaint here that alleges that on or about August 5th, 2025, that you allegedly committed the act of controlled substance possession of cocaine, heroin, or other narcotic less than 25 grams, and that on or about the date in question at South Cedar Street in Kalamazoo, Lansing, Michigan, Ingham County, that you did knowingly or intentionally possess less than 25 grams of a mixture containing the controlled substance cocaine, and this is in violation of MCL 333.740328B. That's a felony, maximum penalty 4 years and/or $25,000 in fines. You understand the charge and the penalty, ma'am?
Yes,
You are represented by the Public Defender's Office to be arraigned today, but you do have the right to counsel and the right to be appointed counsel if you cannot afford to hire one. You understand that?
yes,
You have the right to have an attorney represent you at all of your appearances in court, and the right to have an attorney represent you if you're questioned by law enforcement. You understand that?
Yes,
Is she requesting the public defender to represent her?
Yes, Your Honor, and I was able to complete an intake.
Or will enter a plea of not guilty on your behalf. You have the right in this matter to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. By standing mute, the matter will continue to a jury trial. This is a felony, so you have the right to a preliminary examination, and you have the right to have that exam within 21 days of today's date unless it's waived by you or the court finds good cause to waive it. You have the right at the time of your preliminary examination to have the prosecutor establish on the record that they have sufficient probable cause that a felony was committed and sufficient probable cause to charge you as the individual who committed the felony. You're currently scheduled for probable cause conference before Judge Cynthia Ward, and it's going to be on August 14th at 9 a.m. You have a preliminary examination before Judge Ward August 21st at 9:30, okay?
yes,
You got a notice to appear for those dates and times, correct?
yes,
You have the right to the presumption that you're innocent, and the right to carry that presumption all the way through to jury trial and require the prosecutor prove each element of the charge being brought against you beyond a reasonable doubt. You have the right to be silent at trial, and they can't use the silence against you. The right to see, hear, or question any witness the prosecutor calls to testify against you. The right to subpoena witnesses to testify on your behalf, and the right to waive your silence and testify on your own behalf. You understand that?
yes,
Do you have any questions about your rights?
no,
Okay. Let's see. I do have a pre-arraignment report here, and it says that you're currently without housing. Is that correct?
did I what?
The report that I have here indicates that you are currently without housing. Is that accurate?
Yes. Well, I'm staying at the Quality Inn until Saturday.
You're staying with whom?
I'm staying at a hotel till Saturday. If I, it must be, I'm also going to a New Hope Center to stay there at night.
What hotel are you staying at until Saturday?
Quality Inn, a hotel.
And then you said you're going to Mount Hope after that?
Yeah.
Okay. What's your phone number?
517-485-0145.
Are you currently on probation?
No,
Are you on parole?
no,
Do you have any other court cases pending?
no,
Have you ever missed court in the past?
no,
You can address bond counsel.
Thank you, Your Honor. As this is a controlled substances felony, nonviolent offense, I'd be requesting a PR bond at this time.
I do, again, reviewing the pre-trial services pre-arraignment bond. Again, it does indicate her prior criminal history, which looks like her last conviction was in 2025. But the concern that it highlights is that she does, although she just told me she has never missed court before, she has 2 or more qualifying failure to appearance in court.
no, no.
You don't recall that?
I wasn't aware of them. I wasn't aware of them at all.
You wasn't aware of what, of the court dates, or you wasn't aware?
The court dates.
Okay, but do you remember not missing court before and having a bench warrant issued?
Not that I'm aware of, unless it was from my husband. I don't know from who or where, when. No.
No, this has nothing to do with your husband. This has to do with your prior criminal history. That's what they're reporting. But as indicated by your attorney today, that this is a nonviolent offense. You need to make sure you get to all of your court dates.
She's got a husband, and here I sit single. Man, world ain't fair.
Understand
I
that?
know. Yes, definitely. Yes, of course.
Bond is set in the amount of 2,500 personal recognizance. You need to report to all of your court dates. You need to report to pretrial services within 48 hours of your release. Also, within 48 hours of your release, you need to provide an address where you'll either be staying or your mail can be forwarded. I am going to order.
have an address. I'm sorry, but I do have an address.
What's that?
I'm using community mental health address as a mailing address. It's 812 East.
Community mental health is receiving your mail?
Yes, they are. I go there. I see a doctor, I see a counselor, and I have a.
I recognize that, but I'm not aware of that they receive people's mail for them.
Yes, they are for me. Yes, they are.
Okay, I'll note that here in the file. I am going to order that you participate in drug testing 2 times a month while on bond.
Okay.
You're not to use drugs or alcohol. You're not to travel outside the state. You're not to possess a firearm or any other dangerous weapon. And you continue with CMH with your services.
Yes, ma'am.
Do you have any questions at this time?
No, I do not. Thank you.
Okay. Any additional matters, counsel?
No, Your Honor.
You're all set, ma'am.
Thank you.
Yeah, she was a sad case.
Okay, this is the matter of the state of Michigan versus Gregory Osteen, 25-02388. Appearance, please.
Assistant Public Defender Joseph Hardy on behalf of Mr. Osteen.
Someone check his hard drive.
Here, Gregory Osteen.
That's correct, ma'am.
This will road. Okay, let's see here. I have a felony complaint here.
Another felony. I'm shocked.
Mr. Osteen, the allegations are that on or about August 5th, 2025, that you allegedly committed the act in count 1 of controlled substance possession of methamphetamine and ecstasy on or about August 5th at 12225 Clark. I'm sorry, 12224. I might have said too many twos. 1224 Clark Street, City of Lansing, Ingham County, State of Michigan, and that you did knowingly or intentionally possess methamphetamine contrary to MCL 333.74032BI. Now, that's a felony with a maximum penalty of 10 years in prison and or $15,000. Count 1 is carrying a concealed weapon, alleging that you did carry a dangerous weapon, that being a pistol, whether concealed or otherwise, in a vehicle operated or occupied by said defendant, that being a Chevrolet Suburban. And this was in violation of MCL 750.227. That's a felony, maximum penalty, 5 years in prison and or $2,500 in fines and a mandatory forfeiture of the weapon or device under law. There's a count 3 of weapons, firearms possession by prohibited person, alleging that you did possess a firearm when ineligible to do so because you had been convicted of breaking and entering unoccupied dwelling with intent, a specified felony that is punishable by imprisonment of more than 1 year, and the requirements for regaining eligibility had not been met. And this is contrary to NCL 750.224F6. That's a felony with the maximum penalty of 5 years in prison and or $5,000 in fines and a mandatory weapons forfeiture. Count 4, felonious assault with a dangerous weapon, alleges you made an assault upon a John Patrick McDermott with a dangerous weapon, that being a pistol, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. Count 4 is a felony with a maximum penalty attached of 4 years and or $2,000, and a consecutive sentence may be imposed if the assault was in a place of confinement. Count 5, 6, and 7, respectively, are weapons felony firearms, alleging that you did carry or have in your possession a firearm, or that being a pistol, at the time that you committed in count 5 an assault with a dangerous weapon, in count 6.
Holy cows, guys. If you asked me, like, his charges, I completely, I would have stuck to the check his hard drive thing. But I never would have picked him for a violent pew pew offender. He's out there on the streets thugging. This dude's out there on the streets thugging. Wow.
Prohibited person in possession of firearm in count 7, possession of methamphetamine, and that each of these in violation of MCL 750.227B. Each count 5, 6, and 7 are felonies with a maximum penalty of 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction, and there's a required mandatory forfeiture of the weapon or device. You're being charged as an habitual offender. 4th offense notice. It says, take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about September 12, 1990, he was convicted of the offense of uttering and publishing in violation of 750.249 in the 56th Circuit Court for Eaton County, state of Michigan. And that on or about August 29, 1990, he was convicted of the offense of uttering and public or attempted uttering and publishing in violation of 750.249 in the 30th Circuit Court for Eaton County, state of Michigan. And that on or about July 3rd, 1991, he was convicted of the offense of attempted escape from prison in violation of 750.193 in the 30th Circuit Court for Ingham County, state of Michigan. And therefore, the defendant is subject to enhanced penalties under the law. He is facing life because the primary offense has a penalty of 5 years or more. You understand the charge and the maximum penalty, sir?
Yes, ma'am, I do.
Okay, you have the right to be represented by an attorney. Mr. Hardy's representing you for your arraignment, but you have the right to have an attorney at all of your appearances in court and if you're going to be questioned by law enforcement. Do you understand your right to counsel?
Yes, ma'am.
You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You can plead guilty, you can plead not guilty, or you can stand mute. If you stand mute, the matter goes all the way to jury trial. You have the right to have a preliminary examination in this file because you are being charged with felonies. You have the right to have the preliminary examination within 21 days of today's date.
I got it. Breaking Bad. That's it. Dude, it's the Breaking Bad dude. That's why he needed all the pew-pews.
Unless you waive that 21-day timeline or the court finds good cause to go beyond the 21 days. You have the right to have the prosecutor establish at the time of the preliminary examination that they have sufficient probable cause that the felonies alleged were committed, and then sufficient probable cause to charge you as the individual who committed those felonies. You are scheduled for probable cause conference before Judge Cynthia Ward. And that's going to be on August 14th at 9 a.m. You have preliminary examination before Judge Ward on August 22nd at 9:30 a.m. You must appear in person. You understand that?
Yes, ma'am, I do.
Yeah, the right to the presumption that you are innocent, and you are innocent until proven guilty, and you can maintain your innocence and require the prosecutor take this matter to jury trial and prove each element of the charges that are being brought against you beyond a reasonable doubt. You can continue your silence at trial. They cannot use silence to prove or imply that you are guilty. You have the right to see, hear, or question any witness called to testify against you, the right to subpoena witnesses to testify on your behalf, the right to present evidence that show a defense to any of the charges, and the right to waive your silence and testify if you'd like. You understand?
Yes, yes, Your Honor.
Is he requesting the public defender's office, counsel?
He is, Your Honor, and I was able to complete an intake today.
Okay, the court's going to enter a plea of not guilty on your behalf. Are you employed?
No, ma'am, I filed for my disability, and I'm having a long fight with that due to I was injured by a dog, and it screwed me up mentally and physically, and I can't work right now. Very little work. What I can do is like lawn care or something like that. Not strenuous, but I can work very little. I work around the neighborhood, do some work like that. Try to help support myself through my sister. No, that's it.
Where do you live?
213 Douglas Street, Lansing, Michigan, 48906.
What's your phone number?
517-37.
Are you currently on probation?
No, ma'am.
Are you on parole?
No, ma'am. I completed all that years ago.
Do you have any other court cases pending?
Yeah, no.
Not that you know of?
No, ma'am, not that I know of.
Have you ever missed court in the past?
Yes, I did do to make it with a ride. And then the other incident was health. I was in the hospital, went to the hospital.
You say you missed court in the past because you couldn't make it because what?
No vehicle, I couldn't drive, and I had no vehicle to ride up there. It was in the other county up in St. John's.
It's up in St. John's? Oh, and then when was the other time you missed?
It was here in Lansing, I believe, and then I had to go to the doctor's, the hospital. I was
Oh, so
sick.
you only missed in Lansing once?
Yes, ma'am, I know of. Yes, ma'am. Okay. Wish I didn't get nothing.
You don't have any cases pending?
Oh, ma'am.
That's interesting because I have two files here. One is 21-01912, says that you have a case pending. It's for driving while license is suspended. Don't talk when I'm talking. Driving while license is suspended. It says you failed to appear for arraignment in August 2021. Then when you were finally arraigned 2 years later in 2023, you were given a pretrial date to appear on April 18th at 2 p.m. April 18th came, you failed to appear. There was a new appearance later set for you to now come in January 22nd, 2024. January 22nd came, you failed to appear again. You then later appeared in February via Zoom. The judge quashed the bench warrant and reinstated the bond, and then set it for a hearing on March 25th. And then you failed to appear on March 25th. And so you are currently in bench warrant status on this file after having failed to appear 5 times on that file. Put your hand down. I also have file number 21L26365542 that you are also in bench warrant status on because you failed to appear 5 times. And to which the attorney that was representing you has filed a motion to withdraw as your counsel on that because you failed to come to court and you are in bench warrant status on that. So I don't know how I asked you if you have any court cases pending. You tell me no, and then I asked you if you ever don't talk when I'm talking. I don't know how I asked you. I don't know how I asked you if you ever missed court before. You tell me about something in St. John's and then tell me you only missed court here once a long time ago.
Well, ma'am, this is why I said that.
That's not honest.
No, ma'am, I was being honest. The courts brought me in front of them and told me that they would get a hold of me and send me something to my address later on. I come to them via the telecommunications device or whatever, and the way I understood it, the case was squashed. Maybe it was due to the fact that they squashed part of it or something. I don't know, but it was my understanding, ma'am. I've been through a lot of mental anguish and stuff in my life that's post-traumatic stress disorder. And it's very, very hard for me to calculate everything and then hold it in my mind and keep everything in order by myself.
So it sounds like you don't need to be the owner of Pew Pews. It sounds like they should be confiscated from you and you should never get them back. Although I doubt you have them legally.
I'm glad that you let me know that because I'm happy you shared that because that lets me know that we cannot leave you on your own recognizance because it's very difficult for you to calculate. Don't talk when I'm talking. Don't talk when I'm talking. It's very difficult for you to calculate and keep everything in your mind, which makes sense because you've missed court for 5 times and it's 2025 and we have 2 cases here pending that you've been in bench warrant status on 5 times already since 2021.
Yes, ma'am. I live with my sister.
Stop, sir. Counsel, you can address bond.
Thank you, Your Honor. Regarding the failures to appear, I believe he's already explained that as regarding being related to the PTSD and the memory loss. This is not information that was available to myself. So beyond, I'll just leave that where it is. I will say that the previous felonies that he has been convicted of, for which this is the habitual fourth, those were non-violent offenses. At this point, I would defer to the court's judgment on the, I believe it's 7 counts that he's currently facing, Your Honor.
I do have a bond recommendation from the prosecutor's office. They're requesting a bond based on the following factors. It says a crime charge involves violence towards another person. Crime charge involves the possession and use or threat of a firearm. It says the defendant has a prior conviction for attempting to escape incarceration. The people are requesting $100,000 cash surety with other specific conditions.
Hello.
It also
Well, that's a good one. I get it in my back pocket out here at the desk, man. I think this is a Pharisee of mismalice of justice in any type of form. I feel
Remand.
Thing
I don't go back and forth. He's excused.
Funny.
He's excused. I can't get him out of there. He's remanded. No bond. Bond denied.
Oh, the second dope. Oh man, remand. Love it. They keep finding out hard. Yeah, he heard that 100K. He's like, no. Yeah, well, I have PTSD too, but I don't act like that. Of course, I'm sure it's a different form. Everybody's got some type of PTSD. Everybody's got trauma. His just happens to be with the fact that he keeps getting arrested. He's a dumbass. Oh, man. It's taken a moment for all of them to recover from that. Trying to think of something that won't get me demonetized.
Let's see, what did I do here?
Oh, he was very ill. He's going to need the pocket protector, protecting his back pocket, if you know what I mean. They can sense it.
On the record, in the matter of the people of the state of Michigan versus Justin Plettel, 25-02384. Parents, please.
Assistant Public Defender Joseph Hardy on behalf of Mr. Plettel, who was appearing via Zoom.
You are Justin Plettel.
Yes, ma'am.
This is a felony complaint. The allegations, Mr. Plettel, are that on or about August 5th, 2025. And count one, you allegedly committed the act at area 1516 Marquette Street of assault with a dangerous weapon, that being a felonious assault, and that you did make an assault upon a Kanisha Smith with a dangerous weapon. Count two is also assault with a dangerous felonious assault, alleging that on the same date and time, you made an assault upon a Timothy Isidore minor. Both assaults allegedly to have been committed with a dangerous weapon, that being a rifle, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. Both counts one and count two are felonies, maximum penalty 4 years and or $2,000 in fines. Your DNA is to be taken upon arrest. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Count three, weapons felony firearm, alleges that on the date in question at the same address of 1516 Marquette Street, Lansing, Michigan, that you did carry or have in your possession, that being a firearm, a rifle, at the time that you allegedly committed in count three, the felonious assault, and count four, assault with a dangerous weapon, and that both are in violation of MCL 750.227B. Count three and count four are felonies. Maximum penalties are 2 years consecutively within preceding any term of imprisonment imposed for the felony or attempted conviction, and your mandatory weapon or device forfeiture under the law. You understand the charges read through counts 1 through 4 and the maximum penalty.
Yes, ma'am.
You have the right to counsel. Mr. Hardy is representing you today for your arraignment only, but you have the right to have an attorney at all of your court appearances and the right to counsel if you're questioned by law enforcement. If you can't afford to hire an attorney, you can make a request to have the public defender's office appointed at the expense of the public. You have the right to remain silent. Anything you say, anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter's going to go all the way to a jury trial. You are being charged with felonies here on all 4 counts. So in each count, you have the right to preliminary examination, and you have the right to have that within 21 days of today, unless you waive the 21 days or the court finds good cause to go beyond the 21 days. You have the right to require that the prosecutor establish at the preliminary examination sufficient probable cause that felonies were committed and sufficient probable cause that you were the person to commit those felonies. You're currently scheduled for probable cause conference before Judge Stacia Buchanan on August 15th, 9 o'clock in the morning. You have a preliminary examination before Judge Buchanan on August 22nd at 10 a.m. You must appear in person and you should have received a notice to appear. Is that correct?
Yes, Your Honor.
You have any questions so far?
No, Your Honor.
Okay, you have the right to the presumption that you're innocent until proven guilty, and you have the right to carry that presumption through to the jury trial and require the prosecutor prove each element of each of the felonies being charged against you beyond a reasonable doubt. You have the right to maintain your silence and not do anything at trial and not have that be used against you. You have the right to question and cross-examine in court by way of your attorney, any of the witnesses called to testify against you. The right to subpoena witnesses to testify on your behalf, and the right to waive your silence and testify at your own trial. You understand all of those rights, or do you have any questions about them?
No, I understand, Your Honor.
Are you on probation at this time?
No, Your Honor.
Are you on parole?
No, Your Honor.
Do you have any other court dates pending?
No, Your Honor.
Are you employed?
Yes, Your Honor.
Where?
ZF,
What is that?
it's an I build integrating braking controls for GM, so it's an auto parts factory.
Your home address?
1514 Marquette Street, Lansing, Michigan, 48906.
Well, unfortunately, because this is an assaultive crime, I have to enter a no contact order. You're not going to be allowed to live there because the protected parties live upstairs or downstairs from you. Where are you going to stay?
I can stay with my fiance for the time being. I can give you her address.
Where's that?
7248.
What's your phone number?
517.
Is he requesting the public defender's office, counsel?
Yes, Your Honor, and I was able to complete an intake today.
If the person to enter a not guilty plea on your behalf, counsel, you can address bond.
Thank you, Your Honor. So, as Mr. Plato just stated, he is someone who is employed in the area at CF. So I would say that he's not particularly at flight risk. Is that's a good drive that he's not looking to risk by failing to appear. He stated to me, that he's not someone that possesses a criminal record or
Oh, guess we lost him.
Everybody's internet's going out today. It wasn't just me. We lost the public defender. Where did he go? Okay, let's see if speed this up a little. Ten seconds at a time. Hike them pants up.
my apologies for that, Your Honor. My laptop was at 10%, then it was dead. But Regarding the bond, Mr. Platos has stated to me that, he's someone that, comes to court, someone that is fully employed, someone that has lived in Lansing for 7 years so far, and is someone that does not have a history of committing violent offenses. So while the allegations, are serious, of a violent, felonious nature, I would say that his history does not show him to be someone that requires any type of cash bond. So with that, I'd be requesting a PR bond, Your Honor.
Set in the amount of 2,500 personal recognizance, but with GPS tether. While out in bond, you're not to have contact directly or indirectly with the alleged victims, Kenesha Smith or Timothy Isidore Minor. Do you understand that?
Yes, ma'am.
You're not to be within 2,000 feet of wherever they live, work, or go to school. I recognize that you all live in close proximity with one another. You're gonna need to send your fiance to get your items.
Yes, ma'am.
Okay, you're to report to all of your future court dates. You're not to use drugs or alcohol without a valid prescription. You're not to possess a firearm or a weapon of any kind. You must report to pretrial services within 48 hours. Do you have any questions?
You said report to pretrial service or pretrial services. What does that exactly mean?
You'll get the information from the jail. You need to call pretrial services within 48 hours of your release, okay?
Okay, thank you.
They'll provide you the information with the number to call, okay?
Okay, thank you.
You're welcome. On the record, in the matter of the state of Michigan versus Ron Archer, 25-021323, that is, counsel appearance.
Thank you, Your Honor. Assistant Public Defender Joseph Hardy on behalf of Mr. Archer.
Okay, Mr. Archer, I have a misdemeanor complaint alleging that on or about June 14, 2025 at 3916 Stabler, Lansing, Michigan, Ingham County, that you made an assault or assault and battery upon a Yasmin Bonet Orta on or about June 14th, a resident or former resident of your household, or a person in which you have a child in common, or an individual with whom you have a dating relationship. Count one is a misdemeanor, maximum penalty, 93 days in jail with $500 in fines. Consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. You understand the charge and the penalty, sir?
Yes.
You have the right to counsel. If you can't afford to hire an attorney, one can be appointed to represent you at the expense of the public. You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You can plead guilty, plead not guilty, or stand mute. If you stand mute, the matter is going to go all the way to a jury trial. You are presumed innocent until proven guilty. You have the right to require the prosecutor prove your guilt by proving each element of the charge of domestic violence beyond a reasonable doubt. You have the right to see, hear, and question any witness in court that's called to testify against you. The right to call your own witnesses or present evidence that you believe show defense to the charge being brought against you. The right to be silent and not have silence be used against you, or you can waive silence and testify at your trial if you'd like. You're currently scheduled for a pretrial conference on August 26th at 9:30 before Judge Tony Flores. Did you get a notice to appear?
Yes.
Okay. Counsel, is he requesting the public defender to represent him?
Yes, Your Honor.
The court is entering a not guilty plea on your behalf. What's your home address?
52.
Or what street? Are you staying with someone? Is that why you're giving me that address?
No, I've been renting that house for years now.
Your bills.
I just got laid off from Ryder.
Pay your bills. Employed.
No, ma'am.
How do you pay your bills?
I just got laid off from Ryder. I gotta do a few things to get back in.
What's your phone number?
517-420-7193.
Are you on probation?
No,
Are you on parole?
no,
Do you have any other pending matters?
yes,
Have you ever missed court in the past?
no,
Are you in bench warrant status right now?
what's that?
My records indicate you have a bench warrant out of the 56th District Court.
No, is that Eaton County?
It's Eaton County.
Yeah,
Operating
no, I
while
took care of-
intoxicated, bench warrant.
I took care of that already.
So that means you've missed court before. Correct?
Yes, yes,
Which was the last question I just asked you that you said no, correct?
right, correct.
You can address bond counsel.
Thank you, Your Honor. Mr. Archer is someone who stated to me that he's lived in Lansing his entire life. That while he is on bond out of Eaton County for the OWI, he stated that he's not someone that possesses a criminal record, violent or otherwise. We do acknowledge the previous bench warrant for Eaton County, the Eaton County case. However, I would say that that's not necessarily entirely indicative that he's looking to flee this court's jurisdiction or not show up here. And also with the charge, I would just be requesting a PR bond.
He told you he didn't have any prior criminal record?
Correct, Your Honor.
He lied.
Well, that wasn't the truth. I'm looking at his prior criminal record. He also has a pending OWI. That's how I knew that he had a bench warrant. I knew these answers before I asked him if he ever missed court, and he opened his mouth and told me no, he never missed court. He has convictions for operating under the use of controlled substance. And another conviction that was deferred. So I don't know why he told you he didn't have any prior convictions. He also has been charged with other matters that did not result in conviction. So I don't know why he would relay that information. I don't know why he would say to me that he's never missed court before when he is listed as of today in bench warrant status, other than he's not honest. So I have a concern about that, but nonetheless.
See, when Pinocchio lies, his nose grows. When this dude lies, he gains a cup on his moobs.
Bond in this matter, because this is a matter that typically is released on recognizance. I will grant the personal recognizance bond, but you are going to be released with GPS tether.
Okay.
Bond is $500 personal recognizance with GPS tether.
They're used to being able to manipulate their victims. They come in front of a woman judge, and they think they've got it easy. Yeah, absolutely.
You're not to have contact directly or indirectly with the protected party in this matter, Yasmin Orta. Do you understand that?
Yes,
Not to be within 2,000 feet of wherever she lives, works, or goes to school. No contact directly or through third party. You can't have anybody else call on your behalf. You can't text. No communication of any kind. You're not to travel outside the state without prior approval of the court. You're not to use a firearm or possess a weapon of any kind. You're not to use alcohol or drugs unless you have a valid prescription. Do you have any questions?
No, ma'am.
Any additional matters for the record, counsel?
No, Your Honor.
You're all set.
He may be the last one. Not a lot left on that timeline. Well, I guess there is maybe. Oh, yep, we got more. One more. It's an encore.
This is the matter of the state of Michigan versus Nicholas Diaz, 25-02385. Appearance, please.
Assistant Public Defender Joseph Hardy on behalf of Mr. Diaz.
Mr. Diaz, I have a misdemeanor complaint that you need to be arraigned on here. Let's see.
This is the one time that I would believe the argument of not my pants. You could fit another one of him in those pants. They're literally just hanging off. Wow. I believe you, dude. Not my pants.
The allegations are that on or about August 5th, 2025, at 524 Erie Street, Lansing, Michigan, Ingham County, that you allegedly committed the act in count 1 of domestic violence and that you did make an assault or assault and battery upon a Tyja Plummer, an individual whom you have a dating relationship, and this is contrary to MCL 750.812. This is a misdemeanor, maximum penalty 93 days in jail and or $500 in fines. The consecutive order may be imposed if the assault was committed in a place of confinement. You understand the charge of the maximum penalty?
Yes, ma'am.
Okay. You have the right to be represented by an attorney. Mr. Hardy's going to represent you today so you can be arraigned. But you have the right to an attorney if you're questioned by law enforcement or at all of your court appearances, okay?
Yes, ma'am.
If you can't afford to hire an attorney, you can make a request for the public defender to represent you at the expense of the public. You're presumed innocent until proven guilty, and you have the right to require the prosecutor to take this matter to jury trial and prove each element of the charge being brought against you beyond a reasonable doubt. You have the right to be silent at your trial and not have that silence be used against you, or you can waive silence and testify on behalf. You have the right to present witnesses or subpoena witnesses that will testify for you and present evidence that you believe show a defense to the charges being brought against you. You have the right to see, hear, or question any witness the prosecutor calls to testify against you. Do you have any questions about any of those rights?
No, ma'am.
You are scheduled for a pre-trial conference before me, Judge Kristen Simmons, is going to be on August 18th at 8:30 in the morning. Did you get a notice to appear?
Say that one more time, please.
Did you get a notice to appear?
Yes.
Okay,
You got it right here.
very good. Is he requesting the public defender?
Yes, he is, Your Honor, and I was able to complete an intake with him.
Okay, the court's going to enter a not guilty plea on your behalf. Are you employed?
Yes, ma'am.
Where?
I work at Rose Scott's.
What do you do there?
I'm a chef. I cook.
He's acting respectful.
What's your home address?
905.
Is that the address of Miss Taija Plummer?
No, that's my mother's house. That's where I've been staying.
Okay, what's your phone number?
I was,
Are you currently on probation?
no,
Are you on parole?
no,
Do you have any other court dates pending?
not that I know of.
No other cases at this time?
No.
You ever missed court before?
I have once before, yes,
Oh, just once?
just once,
No.
my knowledge.
Well, let's see, City of Lansing versus Nicholas Diaz, 23-02014. Failed to appear July 13, 2023. Failed to appear September 19, 2023. Failed to appear April 1st, 2024. Failed to appear April 4th, 2025. Failed to appear May 6th, 2025. People of the City of Lansing versus Nicholas Diaz, 25-00508, failed to appear May 6, 2025. All of these cases are assigned to me, sir.
Understand?
Did you forget about all those failure to appears when I asked the question?
I don't remember having those court dates.
Oh,
Only thing
okay.
that I know, only thing that I noticed that I had was the instruction, failed to obey.
Hinder, obstruct, oppose, and a failure to obey, and the other one's hinder, obstruct, oppose, and trespass. And you've already used the I didn't know like 3 times, like literally 3 times you came, I didn't know I had court. You told the magistrate that in 2023. In 2025, you said the same thing. I didn't know I had court. And so you don't have the recognizance sufficient for a personal recognizance bond. Counsel, you can address bond.
I will say that Mr. Diaz stated to me that while he does have a criminal record that none of which that he's committed before is violent. You just went over the failures to appear, so it's clear from the record that this has become a habit. But I will say that at this time, he does have deep roots here from his job and also living in Lansing. So at this point, I will defer to the court's judgment.
If he told you that none of his prior convictions were violent, that too is false. Maybe he forgot about that too. But you must have forgot. Bond in 25-02385 is $500 cash only with GPS tether. While out on bond, you're not to have contact directly or indirectly with the alleged victim, Taija Plummer. No calls from the jail. No text messages, no DMs, no smoke screens, no algorithms, no blimps, no forms of communication. Do you understand that?
Yes, ma'am.
You're not to be within 2,000 feet of wherever she is for any purpose. You will wear GPS tether with victim notification if possible. You're not to travel outside the state without approval of the court. You're not to possess a firearm, ammunition, or weapon of any kind. You're not to use drugs or alcohol. And you must report to your court dates, which you have received a copy of the court date. Is that correct?
Yes, ma'am.
Your failure to obey in 23-02014 will be set for pretrial September 2nd at 10:30. Did you receive a copy of your court date for that one? Excuse me?
I said I got all of that right here.
Okay, bond in that matter, $250 cash. No PR 14 days. You must appear to all of your court dates. Hinder, obstruct, oppose, and trespass 25-00508. Your pretrial is September 2nd at 10:30. Did you get a notice to appear?
Yes, I got all of that.
Okay, wonderful. Bond. $250, cash only. You must appear to all of your future court dates and follow all previous bond conditions. Do you have any questions?
No, ma'am.
Any additional matters for the record, counsel?
No, Your Honor.
You're all set. Thank you.
Wow. By far my favorite line. You don't have the recognizance for a personal recognizance bond. That made everything worth it. Every bit of it. Oh my gosh. That was so much fun. We had over 2 hours of Judge Kristen Simmons just laying it down. We had 2 defendants that got her to actually scream remand, remand, remand. And I mean, it's not like they didn't deserve it. And we had, how many was that? Like 4 or 5 of them that thought that they would lie. Oh, bless you, sweetie. You good? I think the sneezes are coming from in the box. I think Tiny Kitten's sneezing. Esquire, you good, baby? Because I don't see any. There's no other animal in here, unless Ava's outside the door. Somebody has the sniffles. Oh, yeah, I was gonna show you. Thank you for reminding me. Yeah, let me just get back to it. She's at the very beginning. So give me just a second here. Okay. So here she is right here. She sometimes wears her hair like all completely pulled back slick. And sometimes she'll put it in like a bun on the back. But most often it's very much poofy.
In that on or about July 19th, 2017, he was convicted.
Let's see if I can zoom in on her. I know I can do this. Zoom, do. Yeah, there we go.
Of the offense of home invasion, 3rd degree in violation of MCL 750.110A, or in the 30th Circuit Court.
So there, now you've gotten to see her. She is a wonderful judge. Yeah. My sentiments exactly. I knew it was coming. The moment she was like, one time, really? I was like, oh no. She's got receipts. All right. So that's Judge Kristen Simmons zoomed in at 500%. So let's put her back to 100. Gotta keep it 100 around here. Yeah. Okay, give me just 1 second, Eileen. Give me 1 second, sweetie. Hold up. Hey, caps lock's on. Well, here, maybe you can see this. Hold up. This is her YouTube channel. This is how I'm most familiar with her hairs, where she's got it pulled back and then puts it into a bun like a crown. She's so beautiful. But that's her. And there's not glass around her desk. Like Judge Perkins has, because you'd mentioned that. Just beautiful wooden courtroom.
What matter are you here for and in what capacity?
My name is.
I'm so glad. I am so glad that I was able to cheer some of y'all up. She is absolutely gorgeous. All right. I think, okay, so it's been nearly 3 hours. I think I'm gonna take a break. Maybe, let's see, what time is it? Oh, he's not home yet. Maybe by the time y'all see me again, I'll have some curtains. And maybe while he's putting the curtains up, maybe I can talk him into moving a couch or a bed. I don't know. I'll make it his choice. Her courtroom is gorgeous. It really is. Yes. All right. Thank you guys for coming and hanging out with me. You've been amazing. Yes, you guys have been so wonderful. I love every one of you. Oh, and thank you for sticking with me through the technical difficulties when my internet completely went down. Oh, bogus. Be safe, be well, sleep sweet, and much love.